Well, good afternoon, and welcome to today's webinar presented by Beresford Booth. My name is Per Oscarsson. I'm a member of the Estate Planning and Probate Group here at the firm. The topic today is transfer on death deeds in Washington. So let's start with, what are transfer on death deeds? It's a form of estate planning tool that's been available in the state of Washington for about the last 10 years. Other states have them as well. I think some have had them for longer than Washington has. This is a deed that only takes effect upon death and results in the property that is the subject of the deed not being involved in any probate of the estate. So who can use them? An individual owner of property can use a transfer on death deed. It's not available for properties that are owned by an entity, such as hopefully no property is owned by a corporation, but a limited liability company, for example, or an estate could not use it. However, those types of entities can be the beneficiaries or grantees under such a transfer on death deed. It could be an individual or multiple individuals. It could be a corporation, could be a limited liability company, trust, partnership, or estate. Again, that can be a potential recipient of the property. So the form of the deed is important. Transfer on death deed has the same elements and formalities as a deed you would see in a typical real estate transaction. You have to identify the grantor, the owner of the property, sometimes known as the transferor. And there may be more than one. We won't be dealing with situations where you have more than one grantor in this webinar. You need to identify the grantees, the intended recipients, may also be known as beneficiaries of the deed. You have to have a full legal description of the property. You have to include the tax parcel number or tax parcel numbers, because you could have more than one piece of real estate being the subject of a single deed. And then the deed must be signed by the grantor or grantors, and the signatures must be properly notarized. One difference with the transfer on death deed is that the deed must state that it is effective upon the grantor's death. And then it also has to be the deed has to be recorded in the real estate records or the real property records of the county where the property is located, and that must happen before the grantor's death. So some of the aspects of the deed, first, they are revocable. The grantor can revoke it at any time, preferably by, having to file some sort of a document in the same county records. It could be a new deed. It could just be a revocation. And this would be true even if the deed, for some reason, otherwise says that it is not revocable. Statute, law of the state of Washington provides that it is revocable. The deeds are non-testamentary. Testamentary normally refers to something like a last will and testament, and there are certain requirements for that. In Washington, for example, a will, when it's signed by the maker, must have two witnesses who actually physically witness the maker signing the will. Transfer on death deed is non-testamentary, so you don't need witnesses. However, again, you do need to have the signature of the grantor of the will be notarized. The capacity, basically the mental capacity necessary to do a transfer on death deed, is the same as for a will. And that is basically that the grantor knows what kind of a document they're signing and generally knows what it will do, knows what the property is, and hopefully just it makes some sense who the intended beneficiary may be. That can be a question with a will, that if there's a beneficiary that, for example, no one in the family is aware of or knows, there could be some question about the validity of the will, and that also could go to to the mental capacity of the maker of the will. In this case, also, notice to the intended beneficiary or beneficiaries, delivery of the deed to them or an acceptance by them is not required. So, for example, a transfer on death deed could be made to another individual, and the individual may never know until after the grantor has died that there is this deed in their favor in the real estate records. Hopefully they have some knowledge, because in order to perfect the transfer after the death of the grantor, the beneficiary does have to take some steps with the county. There's also no consideration required for such a deed. Consideration is anything that's given in exchange for the deed. That could be cash, it could be some other form of compensation, it could be other property that could be given in exchange. With the transfer on death deed, consideration is not required. What's the effect of a transfer on death deed during the transferor's or the grantor's life? I could have left this screen completely blank because there really is no effect. So the transferor still has the same interest and right in the property during their lifetime as they had before the transfer on death deed was recorded. They could sell the property, they could mortgage the property. It also does not affect the intended transferee's interest or right in the property, because again, the deed does not take effect until the transferor or transferors die. It does not affect any interest or right that a current or future creditor of the grantor, transferor, may have. So for example, if there's an existing mortgage on the property, then the recording of a transfer on death deed does not affect that mortgage. And if it were to go into default for lack of payment, for example, the lender could still foreclose on the mortgage. It also does not affect, the transfer on death deed does not affect the transferor's or the designated beneficiary's right to get public assistance. Again, because there's been no change in the ownership of the property. It also does not create a legal or beneficial interest in favor of the designated beneficiary. So for example, they would not be able to get a mortgage on the property because at the time during the transferor's life, the transferee does not have an interest in the property. So at the transferor's death, the property then passes to the designated beneficiary or beneficiaries. There is no real estate excise tax transfer on the transfer of the property because there's an exemption similar to when property passes through probate. There is an inheritance exemption, so no real estate excise tax is due. But after the transferor has died, the beneficiary or beneficiaries must file with the county a real estate excise tax affidavit to claim the exemption for the inheritance. Again, when the transfer on death deed is recorded during the transferor's lifetime, then no real estate excise tax affidavit is submitted at that time. I mentioned earlier I wouldn't be talking about where you've got multiple grantors. There can be a number of issues with having multiple owners and how they own the property, and that's a little bit beyond the scope of this webinar, so we may save that one for a future time. Also, there are no warranties of title that go with the property when it's transferred by a transfer on death deed, even if the deed says otherwise. This would compare to, for example, a warranty deed or a bargain and sale deed, two different forms of deeds that are available in Washington and in many other states, although possibly by different names. A warranty deed has a number of warranties in it, whether they are stated in the deed or not, because state law provides for that. The bargain and sale deed provides some warranties. Again, those would normally be included whether or not the deed actually specifies them. However, when it's a transfer on death deed, then there are no warranties of title, similar to a quitclaim deed, which is basically a deed that says, I'm granting you whatever interest I have, but I'm not telling you whether or not I even have an interest, because I may not have. But whatever I have given to you. So there are no warranties in that kind of deed either. But definitely with the transfer on death deed, no warranties of title, even if the deed says otherwise. That concludes today's brief webinar on transfer on death deeds. As I mentioned, there are some other issues that can pop up, multiple owners being one of them, that we will probably say for another webinar for another day. Please, if you have any questions, please give me a call at the number on the screen. And please join us next week when a member, I think Lisa Doe of our Family Law and Assisted Reproduction group, will be presenting a webinar Thursday. Thank you very much. Goodbye.